Hello and welcome everyone. Today we are going to take a look at a decision from Munich that was delivered in the beginning of this year. We had, in this case, Nokia as the claimant and Asus as the defendant. This is a case that deals with two topics particularly that have been very prominent, especially in the case law of the District Court of Munich lately, which is on the one hand the topic of the security that the implementer, that the defendant in this proceeding shall provide, based on, of course, the Huawei ZTE ruling that is the basis for that obligation, for that duty. And the second one is an equally important point, which refers to the assessment of the offer of the patent owner. So what are the factors that need to be considered? How is this assessment to be done? The court provided guidance in this ruling regarding both of these questions. It was not, however, not the first time that the court did that. In another ruling, which was between Willus and Asus again as a defendant, and we have covered, I think maybe 2 months ago, the court had provided also some guidance regarding these two topics. In this ruling here, which came later, a couple of weeks later, there is basically a repetition of some of the principles that the court had set up in the first decision, in the Willus Asus case, but we have also on top of that some more details regarding some of these questions, and we have also a more detailed guidance on another very interesting topic, which is how to deal with parallel proceedings, especially parallel proceedings in the UK regarding rate setting, or even more specifically here, a decision or a declaration of terms for an interim license. So this is something that the court covered here in this case much more in detail than in the previous one. So we're going to look at that all in more detail in a moment. Before going there, very quickly, some background of this case, as always. So there were negotiations between Nokia and Asus for a license. Important when we talk here about a license, we talk about a license on standards that are video coding standards, if we want to put this in a general manner. Particularly, we're talking about a portfolio that reads on the HEVC standard. So there were negotiations. They did not lead to a conclusion of an agreement. And then at some point, Nokia made an infringement notification, again, notifying Asus that there is a need now to take a license, that there is infringement of specific patent. And shortly after that, Nokia also filed the present lawsuit before the Munich District Court. Asus responded, in a sense, by initiating proceedings before the UK High Court. And these were proceedings which concerned rate setting, so the determination of the terms for a license to Nokia's portfolio. But also there was a request for an interim license declaration. When we talk about an interim license here, maybe just to give some context, we're talking about declarations sought by an English court, in particular here, which sets the terms of a license that shall apply basically in the interim stage until the UK court has made a final determination of the front terms and conditions for a license agreement. So this is something just saying that for the interim, until there is the final determination there, these parties are advised to basically agree on these terms as an interim license. This decision was indeed delivered by the UK High Court before the Munich District Court had provided its decision here. So during the proceedings in Munich, there was indeed a decision or a declaration of the UK High Court regarding this interim license. And we're going to see in a moment how the court the Munich court believed it should be considered in the present case. Then the Munich District Court delivered its ruling, which we're looking at today, and it was a ruling that was very much in favor of Nokia. The court, among other remedies, also granted an injunction against Asus. These cases will very likely not go any further because it was then publicly announced a couple of months after the Munich ruling that the parties have signed a license agreement which ends also all pending litigation. So I don't think that we will see any more cases or any more decisions coming out of this dispute in the future. Nevertheless, let's take a look at this decision here. And as always, we will focus on the front defense that was raised by the defendant, by Asus here. The court at the end of the day dismissed the front defense and therefore granted an injunction. And it's interesting to see generally how the court thought about the front defense here. The court assumed that Asus had been willing. We're going to see in a moment exactly why the court reached this conclusion, or why did it follow this assumption. Basically because it considered that Asus was willing to pay a sufficient security, or had paid a security which might not have been perfect, did not tick all the boxes, but the court found that Asus had been excused by because of certain special circumstances here. So it did not find, let's say, a fault in Asus behavior. It assumed that it was willing, although again, it did not fully comply with what the court has established here as conditions, especially for the security payment. So the court focused then on Nokia's offer, especially Nokia's last offer to Asus, which would be the most determining element in these proceedings here, because if the offer would be found to be front or within the front range, then this meant that the way to an injunction would be open. On the contrary, if the court would find that the offer of Nokia had not been within the front range, then the outcome would be likely exactly the opposite. But the court made this assessment, as we're going to see in a moment, and found then that the last offer of Nokia was within the front range. So that's why the front defense was dismissed. Let's look at the first part, the security, and what the Munich court particularly considers to be sufficient security to be provided by the implementer, by the defendant in these proceedings. Now, very generally, this is a requirement that goes back to the Huawei versus ZTE decision. We all know that this is the basis for the relevant case law here in Germany, and this is also the basis for the front defense in most of the cases before German courts. So the Court of Justice of the EU in Huawei has established these duties of the parties regarding the negotiations. It has required the patent owner to make a notification, the implementer to express willingness to obtain a license, then the patent owner shall make an offer on front terms, and if this offer is rejected by the implementer is required to make a counteroffer. And here is where we have this decisive element that the court discussed a lot here. When this counteroffer is dismissed by the patent owner, the implementer is required to provide adequate security. Now, what does this mean? The court laid down these principles of what an adequate security is in the previous decision we discussed already, this Wilus versus Asus case. And basically, it made clear that there are two elements to this security payment, or to this to providing sufficient security. The first one is an actual payment of the undisputed amount between the parties. So the implementer, the defendant, is required to pay in a non-refundable manner an amount which is undisputed to the patent owner in terms of an advance payment. This means that the money that is being provided in this context stays also with the patent owner. So in a sense, it's actually licensing income that can be booked. What is the undisputed amount? This will regularly be the amount of the counter offer of the implementer. The reason is, I think, here clear, because if you are an implementer and if you make a counter offer, then in a sense, for this amount, you recognize that you will or you should also pay a specific license fee. And even if this is, let's say, less than what the patent owner requires or requests, at least to the extent that you, as an implementer, offer to take a license on a specific amount, this amount is not longer into dispute. So both parties agree that this is basically the minimum that should be paid, if we want to put it in other words. So the court said for this part, for this undisputed amount, you need to make a payment, an advance payment for the royalties that will be paid under the license in the future. This can, however, under circumstances, not be enough. The court said here there is also a duty to provide additional security, meaning on top of this undisputed amount, which would amount to the fees that you would need to pay under a license for 1 year of license, under license. This duty exists, however, when specific conditions are met, and the court established which these conditions are. You will need to have the counteroffer of the user being less than 60% of what the patent owner requests, and the difference between the counteroffer and the patent owner's offer should be more than $10 million. So the court said if we have this type of difference, discrepancy between counteroffer and offer, it's not sufficient just to pay the undisputed amount. You will need to pay also security on top of that. And here, of course, we're talking about security. So this is not really an advance payment as in the terms that we are talking about when we're talking about this undisputed amount. So this is an additional obligation, a second element of what adequate security means according to the Munich District Court. So this is, again, something to keep in mind here, because this was something that was not fully met by Asus in the present proceedings. What the court also made clear is that if you, as an implementer, initiate proceedings abroad for a rate determination, these proceedings can have an impact on the amount that needs to be paid as an adequate security. In more detail, the court said the amount that the implementer suggests in the foreign proceedings shall be paid to the patent owner in a form of an advance payment. And if you have a situation where the foreign court, as we had here, sets also another licensing fee amount for licensing fees, for example, in terms of an interim license, this amount should be security provided on top of the undisputed amount. So these are the general principles that the court had established here of what an adequate security is and what the defendant or the implementer is required to do. Now here in the present case, Asus had, let's say, fulfilled only the first part. So the court accepted that Asus paid or wanted to pay. At least in the judgment, it's not clear whether we had an actual payment, because the court says there at some point that Nokia had some difficulties booking this amount. So it's not 100% sure whether there was an actual payment, but the court was in any case satisfied that Asus wanted to make this payment of this undisputed amount based on its last counter offer. There was one question here whether this had potentially been belated because Asus was willing to pay this amount or wanted to pay this amount at the very last moment before the oral hearing. But the court said this is not decisive here. It does not make any difference regarding to the question of whether you would consider Asus to be willing or unwilling. So the fact that they would make this payment was sufficient. The timing was, according to the court, not so decisive here. So this was the first element what Asus had fulfilled, had complied with here. But Asus did not pay this additional security. Although the conditions that we discussed a minute ago would have been met in the present case, which would mean basically that in overall terms, the security provided by Asus was not sufficient in the sense that it did not meet the requirements that the Munich District Court had set. However, the court decided here to not see that as a fault that can be attributed to Asus. The court accepted in a sense that there might have been a need to clarify that apart from this payment of the undisputed amount, you would need to do something further to provide this additional security. And it agreed to a certain extent that although this duty to make this additional security payment could be very well extracted from the guidance that the court had provided, also in a previous opinion that had been published before these rulings here, it said that it was crystal clear only when the court had published its Willis versus Asus decision, which, however, had taken place only after the oral hearing in the present case. So the court accepted that it might have been a bit confusing, if we want to put it in simple terms, for Asus, how far its duty went, and therefore excused, in a sense, the fact that Asus did not pay this additional security in the present case, although it actually should have done. So that was the decision of the court here regarding the security payment. And in that context, the court also gave some input here on the interim license declarations that we had in these proceedings. So we've seen already, in principle, if you have a court abroad being called upon by the defendant to make a rate determination, we've seen that in principle you will need to consider that when it comes to what is an adequate security that the defendant needs to pay in the German proceedings. Apart from that, the court also made some more, let's say, fundamental observations here regarding how the interplay between these declarations, these interim license declarations, and German infringement proceedings is. And this is something very interesting for us to look at because it, I think, would apply also more generally to this type of parallel litigations involving courts in more than one jurisdiction. Now, what the court said here, in answering a very basic question, of course, which is this declaration, is this order of the UK court preventing the German proceedings to move on, preventing the parties to move on with the German proceedings that run in parallel? The court clearly said that this is not the case. The court did not believe that the declaration on the interim license that came from the UK has a binding effect for Nokia with respect to Germany. It rather considered this declaration as an offer to Nokia, which would allow, if Nokia would accept this offer, to move on with the rate setting proceedings in the UK. So the court did not see any binding effect of this declaration with respect to the proceedings in Germany. The court also saw no basically agreement in place, interim license agreement in place, that could block the German proceedings either, because Nokia did not accept this offer, so it did not enter into a interim license with Asus on the terms that the UK court considered to be reasonable. So also from that perspective, the court said there is no let's say, no problem with the German proceedings, they can move on because there is no license there that eventually could have excluded infringement, because the patents, also the German patents, would be licensed also in the interim basis. So there was no license there. This meant that the proceedings in Germany could move on. In that context, there was another question, however, which is interesting. And the question is, since Nokia did not accept this offer of the English court, it did not enter this interim license, does this fact play a role in the overall assessment of Nokia's behavior? For example, or maybe the more important question would be, can you conclude from the rejection of this interim license that Nokia is not willing to provide a license to Asus, or is an unwilling licensor? The court said clearly that this is not the case. So you cannot have these implications from not accepting this interim license in the UK on Nokia. You cannot basically reach this conclusion. And the reason for that is that, according to the Munich court, a party cannot be required to submit against its will to the order of a court that manifestly lacks jurisdiction to set a worldwide license with extraterritorial effect. So the court basically said here that you cannot say that a patent owner or any party is not willing to license or to obtain a license because it is unwilling to comply with an order of a court that has no jurisdiction to do the things it's been asked to do. And this was expanded a bit further because the court also noted that generally it is unclear what consequences the rejection of this interim license have. And not only that, the court questioned here a little bit whether this type of orders is legitimate in a sense, because the court noted here that the UK court should be aware that it lacks jurisdiction to set global rates between a Finnish and a Taiwanese company, so that this interim license declaration as such seems, in the eyes of the Munich court, to be a breach in the legitimacy of the jurisdiction of the UK court. So again, I think here the court made clear that this interim declaration cannot have an impact on proceedings, and you cannot only say that with respect to whether the proceedings should move on or should not move on, but it has not also an impact regarding the assessment of the parties' behavior, because exactly it is very questionable, at least in the view of the Munich District Court, whether the UK courts have jurisdiction or have the authority to do this type of declarations or to assume jurisdiction for this type of rates, global rate setting. There was a final element here, which was discussed also by the court, which was the question: if you assume that the proceedings in the UK were started in order to prevent the German infringement trial to move on. And the court said that, at least in its view, this was not very much contested by the parties, not even by Asus in the proceedings. So there was maybe a thought to have this proceedings in the UK in order to have a declaration there that would block the German proceedings. Then the question was posed, can this fact now have an impact on the German proceedings, in the sense that it would eventually lead to a conclusion that the party that asked for that, Asus in the present case, was unwilling or should be considered to be unwilling in the German proceedings? The court again here said that per se you should not reach this conclusion. So if a party has sought a rate determination, global rate determination abroad, or has sought this interim license declaration abroad, you cannot always per se say that they have been unwilling. You need to look at the specific circumstances of the case, and this is something that the court did not see here to be concerning. However, and this is something to keep in mind, the court said now that Asus has taken this step and has engaged this foreign court and asked the UK court to set global rates and has asked the UK court also to provide this interim license declaration. In order to demonstrate willingness now, Asus must voluntarily comply with the terms of the UK interim license. So it's not that you can per se, without any other consideration, consider that filing these requests abroad will lead to a demonstration of unwillingness on the side of the implementer, of the one who started these proceedings. But if you do, then you need also to comply with what the foreign court has said in order to be able to be considered willing in German proceedings. And a part of that is, of course, what we mentioned before, that you need to consider what the court has determined or what you have suggested in the foreign proceedings for the calculation of the adequate security, for example. So this was also the court's view, or let's say some thoughts of the court here regarding this interplay between the German proceedings and this type of UK interim license proceedings and declarations. We have seen now that the court assumed that in the present case Asus had been willing, so it turned to examine the offer of Nokia, the last offer of Nokia. And here the court made, on the one hand, some general remarks, established some general principles, let's call it, and then also looked at the implementation of these principles in the present case by Nokia. Now, a fundamental question here is how to do this exercise, how to do this assessment of whether the offer has been front or not, has been within the front range or not, which methodology should be used. And here the court very clearly opted in favor of the comparable licenses approach. The court said the comparison with licenses concluded by the patent owner is the preferred and most precise way to assess front. And this is something that the court had already said in the Wilus versus Asus decision, which was delivered previously here in Munich. The court said that the licenses of the patent owner, again, have a very strong indicative value, particularly those licenses that have been signed recently and with parties of approximately the same size and comparable product portfolio. Very strong indicative value have, according to the court, also licenses that have been concluded without the pressure of pending infringement proceedings. Does this mean that licenses that have been concluded after litigation are ruled out as comparables? The court here was very nuanced. It said the fact that there was litigation and eventually even a court decision before the signing of a license, comparable license, should not be overrated. Why? Because the court saw that there is a non-negligible part of the market participants that is not prepared to sign a license without litigation. So in a sense, according to the Munich court, litigation is a normal and acceptable part of negotiations. And the court also could not observe that pending infringement proceedings have a threat effect that is so strong that creates pressure to the parties, especially the implementer, ruling out free negotiations. So again, the court said, of course, licenses that have been signed without litigations have a very strong indicative value, but you have to be cautious. You cannot exclude licenses that have been concluded with litigation because the effect is not so strong as people think, and you cannot rule this type of agreements out as such, because ending in negotiation, ending in litigation is something that can happen, and the court considered that again part of the negotiation process in certain cases. Now, what type of agreements should be part of the proceedings? What type of agreements should the patent owner produce? Here, the court repeated more or less what it had said in the Wilus Asus decision before. The patent owner must produce those comparables that are relevant to support its claims. Been a little bit more specific guidance. When you have lump sum licenses, you need to disclose as a patent owner also the amount, of course, but also the term and the unit figures that have been used for calculating this lump sum amount. If there is a first agreement between the parties, then you need also to inform how did you treat past uses in this agreement. The question here is, should all agreements be presented? And the court here was cautious to say yes. It rather said no, there is no duty to produce all agreements in the proceedings. Why? Because the court saw here a risk that the implementer, the defendant, would selectively use the data and raise arguments about comparability, missing disclosures, etc., that do not really have any merit in the proceedings and should eventually be avoided. This does not mean, however, that contesting whether a license is comparable or not, or is the proper one to be used for the present case, that this is per se in every case holdout. So the court said you need always to have a case-by-case assessment considering the specific circumstances of the case. However, it was reluctant to say that you would need to produce all agreements. So the responsibility is on the claimant to produce those agreements that support its claims, support its pleadings, but this does not necessarily mean that all agreements should be disclosed. What did Nokia do in the present case? So Nokia presented all agreements that are relevant for the standards we're talking about here. So all agreements that refer to the HEVC and AVC standards, these video coding standards. The court found that by producing these agreements, all of these agreements, Nokia was in a position to demonstrate that the license program it has regarding HEVC is implemented consistently. This license is showed, and the court noted that the program is applied across the board. Basically, there are licensees that are very small and also larger companies. The court also saw that the licensing program offered specific discounts, but said that Nokia had been able to explain that why these discounts are offered, and they did that in a comprehensive and economically reasonable manner. So the question, the court seemed to be satisfied here of the agreements that Nokia had produced. All agreements, again, regarding the HEVC standard. There was some discussion whether Nokia should have produced on top of that also agreements that cover multiple standards. Here, for example, agreements that cover HEVC as well, but expand also to other SEP portfolios of Nokia, for example, in the wireless field. The court said that these agreements are not comparable from the outset. When it comes to licensing only the HEVC standards, you should not rely on comparable agreements which cover also other standards, particularly because the court identified here that the economic interests, when you have these multiple standard licenses, can lie on the strongest portfolio. And it said with Nokia, the strongest portfolio is the one for the cellular standards, which means, in other words, that if you have, let's say, license agreements which cover HEVC and other standards which are probably stronger in Nokia's portfolio or in any patent owner's portfolio, then it is very hard to draw conclusions out of these standards and compare these agreements with agreements that cover only the HEVC portfolio, because the importance of the other standards might be much higher for these multiple standard licenses. So generally, the court believed that Nokia had presented the comparable agreements in a way that it served the purpose here in the proceedings. A very big discussion was then whether there are other comparables except from the agreements that Nokia has signed, And particularly here, the question of whether pool agreements that are offered in the market by especially two specific pools in the present case, whether they are also something that needs to be considered, whether they can offer an evaluation benchmark for the portfolio, for the individual portfolio of Nokia. Now, maybe here's some background, which the court explained much in detail in the decision. You have in the HEVC field these two large patent pools via LA and Access Advance. And according to the court, these two pools together cover around 90% of the relevant HEVC patents. Now, why this offers of the pools or these pool agreements should not be directly comparable is, according to the court, the fact that these two pool offers are, in the view of the Munich court, significantly undervalued. Why? Because the court noted here that both pools are shaped by the membership of key manufacturers of products with streaming capabilities here, which means, in other words, that the licensors of these pools that join there and license their portfolio over the pool are, to a large extent, also the licensees of this pool. So they grant licenses through the pool, but also take licenses from the pool. And in the eyes of the court, this means that you cannot rule out that there is a substantial self-interest of the members of the pool to keep the rates low for the HEVC standard. So in that view, from that perspective, the court was not satisfied that these licenses really represent a market price and can be used as a benchmark for making an assessment of the offers of individual patent owners with their own portfolio. And it made also a brief calculation to demonstrate that. And I think it's interesting to take a brief look at how the court thought about this. So the court said, let's take a look how these rates from the pools, from these two pools, compare to the lowest possible per unit rate that you could have for an individual portfolio, for an HEVC device. The lowest possible again. So it took all assumptions in favor of creating or of basically concluding the lowest possible rate that should be paid for this technology. And it said basically for streaming, for devices that have streaming capabilities, you would have to assume an aggregate royalty burden of 2 to 4% of the purchase price. Then you should deduct this by 1/3, because the court noted here that HEVC is not the only available streaming standard, so there are others. So you should basically make only 1/3 of this aggregate royalty burden for streaming. You should multiply that with the device prices that the court accepted here, the average selling price of a device. And then the court concluded that if you do all of this, this exercise, the minimum price that you would charge for HEVC for different products, for smartphones, it would be $2 per device, per unit. And for PCs, laptops, which was also the product category that was the most important here, Asus focuses on this type of products, it would be $7. And the court added here that this amount would be 2 to 2.5 times lower than what would be realistic. So you could basically charge 2 to 2.5 times the $7 and still be in a realistic level of royalties for the HEVC standard. Now, the court said if you take now these numbers and compare them to the numbers that you would get if you would combine both pools and calculate the 90% shares or extrapolate that to 100%, you would reach that number which is significantly lower. The combined highest possible pool rate would be $1.65 $0.5 for PCs and only $0.7 for laptops. So the court said this difference is significant here. So you cannot really use this pool licenses, these pool offers as a benchmark, because the difference is so significant even compared to the lowest price that you could charge under normal circumstances. So this is again in the eyes of the court clearly indicating that these agreements cannot be used for assessing the front conformity of individual license agreements for individual portfolios. The question then was, we will use the comparable licenses here to make the determination. Should the court do also a top-down cross-check? Top-down cross-check means that the court would apply a different methodology here. Top-down means that the court would try to evaluate what would be the aggregate royalty for the standard, for the specific standard here, then try to identify which is the number of the patents, that the total number of patents that are relevant for the specific standard, and then apportion the share based on the share of the patent owner on the total number of relevant patents. Also apportion this amount there and reach the amount of fees that should be paid for the specific share for the specific portfolio. Generally, the court said this top-down check or cross-check is possible, however, only when you have portfolios with a significant size. So you need to apply this, or you can apply this basically when the patent owner holds a sufficient large share of the standard. Because when you have portfolios of a certain size, then there is a presumption that the innovation that is mirrored in these patents and the filing behavior of the patent owner have converged, meaning that there is a lot of innovation and also a lot of filing, which makes then possible to assume basically that the share in the standard, so how many patents you have, is a reliable proxy for the portfolio value. The court said, however, this does not apply, this logic does not apply when you have smaller portfolios, because the fact that you have fewer patents does not necessarily mean that you have fewer innovation. On the contrary, you can have a high innovation value, which is not reflected in a high number of patent filings, because the patent owner might have chosen to direct funding into R&D and not in filing many patent families as possible. So the court said when you have smaller portfolios, you need to do your determination based on comparables. Top-down cross-check is not a methodology that can work in this type of portfolios, in smaller portfolios. And in the present case, Nokia's portfolio for HEVC patents was seen to be small and not really allowing a top-down cross-check, because it's amounted to approximately 1% of the patents. So the court said top-down we cannot use here, because the portfolio of Nokia for the HEVC standard is relatively low. So here comparables are the only way to do the assessment. And the court indeed did so. And the result was, as we mentioned before, that Nokia's offer was considered to be within the front range. Interestingly, the court said it's in the upper end of the front range, but it's still nevertheless acceptable. 2 points that the court mentioned here, I think, are also interesting, maybe very much specific to the present situation here and the licensing situation when it comes to the HEVC standard. But the court, considering that we have these two pools that license around 90% of the standard on below average low rates, considering that, it thought that Nokia is an outsider because it has, again, only approximately 1% of the share of the SEPs. And it said in these situations where you have these dominant players that license the standard below average low and very low rates, in these conditions, you should allow these outsiders, these companies that have only a minor part of the standard, to have a substantial freedom in pricing in order to be able to foster innovation. Because only if you allow the small implementers, the small patent owners, the outsiders who have only a small share of the standard, to have this freedom in pricing, you would enable them to build and further develop their own patent portfolio. So the court basically advocated here that in these situations, you should allow basically those who have only small shares of the patent to have some leeway in how much they charge for their innovation, because otherwise, if you would take the low prices that the pools have set here, you would not basically give them sufficient incentives to further innovate and develop their patent portfolios. Does this mean that if you have someone in the market that offers very cheap licensing rates for a standard, you can charge how much you want for your own portfolio, or you can raise your rates for your individual portfolio? The court said no, FRAND does not entail that. It does not mean that the patent owner can raise its rates as far as he wants if there is another very cheap licensor. However, again, the court pointed out here we have these exceptional situations with these two pools having a very strong position in the relevant market for the relevant for the licensing of the relevant patents for HEVC. Finally, just one point maybe to include here in our webinar today, to point out, the court said that the assessment of whether an offer is within the FRAND range or not should not be in an abstract manner. It should be based on the patent implementer's portfolio. So specifically, what is the product mix, what type of products, categories the implementer sells, what is the pricing, how many of the products are in the lower price segment, in the higher price segment, etc. So you need to consider that. Because the court said there is a risk that you can have an unequal treatment of patent implementers if, for example, practically all key product categories of an implementer fall under the same highest royalty category. Because then you would basically have no difference in the price, in the royalties based on the price of the products. So you would treat them all basically under one category, and this could be problematic from an unequal treatment perspective. Or the court said it could be also problematic if the increase in the per unit rates between the cheapest and the most expensive product category is relatively high, because the court said that in that case you would eventually benefit those higher end products. So the court just noted that here, and there were some elements of that thinking also in the Wilus Asus decision before. However, this was not something that was here in the present proceedings of relevance, because the court said the model that Nokia follows is rather potentially favorable to Asus, that has products in a relatively high average selling price. So any type of questions around unequal treatment, etc., based on these considerations that I just mentioned, would not really be decisive or applicable here.